law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Solicitors in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors are here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. You are welcome to Heritage TV Hanging Out with Vicky. Today's legal hour, as usual, we've got BWF Solicitors in the house. And the representative from BWF Solicitors is Mrs. Eunice Champon. She is a solicitor and also one of the partners at BWF Solicitors. Today's topic is applying under the partner route. May I also remind all of you that if you want to contribute to the program, please send us your comments, your questions to our Facebook page at Heritage TV and also on BWF Solicitors Facebook platform. And myself and my resource person, Laura Eunice, will be able to pick up those questions and answer them live on this program. We also have a studio number if you want to call live. It's 0203 983 3553. Laura Eunice, you are welcome to the Legal Hour on Heritage TV. How are you doing?
I'm doing well, thank you. And I hope your week has been good.
Yes. Good. We're looking forward to today's topic.
Yes.
When I, the topic on all our social media handles, telling everyone what we discussed this week, I get so many responses, and today is going to be phenomenal because people are, going through. I think they are not too sure how to go about applying a partner rules.
Yeah.
So some of the receiving was overwhelming. We are so excited that we are going to choose it today. And I know you're going to do justice to that. Every week, you're justice of retreat.
Thank you.
My goodness, going straight to the point, how successful will it be making an application within the UK without immigration status?
So this is one of the popular areas, and I think a lot of people are interested in it because you come into the UK for one reason or the other, you become an overstayer, or you entered without the right documentation. And then you are sort of thinking, okay, how do I regularize my stay in the UK? And sometimes you often meet somebody that you may fall in love with, or you feel that you're compatible with, and you start life together. And as time goes on, you want to look at ways you can regularize your stay. And if the person that you are in a relationship with is either somebody who is settled, who probably has indefinite leave to remain, or somebody who has British citizenship, then you're thinking to yourself, there must be a way that I can also rely and depend on this person to be able to make an application to remain in the UK. I mean, prior to July 2012, you would have said that making an application like this would have been fairly straightforward if, for instance, you were able to show that you have lived with this spouse or partner for a period of time, and then you're thinking, okay, let's make some applications and see how best we'll be able to make these applications. But not so straightforward after July 2012, when the immigration rules changed, because there are so many factors to consider. And so people generally would have thought, okay, this must be one of the applications that will get me my stay or get me my leave to remain, so that I can be able to work and regularize my stay and do all the things that I haven't been able to do. But unfortunately, under the immigration rules, you don't have it so straightforward. So today, we're going to be looking at some of the factors that they would consider, which is the Home Office, in making such an application, and what the relevant evidence is, or the necessary evidence that they will be looking at in considering such an application, and what you need to be able to make such an application as well. So we're going to be looking at all these things, and then hopefully people will be more informed as to what to do when they are making such an application.
So that leads me to the next question. Who is a partner under the immigration rules?
Okay, so in terms of our immigration rules, usually you have to look at what we call the introduction. So we have in our introduction, there are various definitions of different terms that are used in the immigration rules. And then when you look at the partner route specifically, that is under our Appendix FM, or Appendix Family Route of the immigration rules. And so when you look at Appendix FM, you also have under Appendix FM our paragraph Gen 1.2. And it says that a person who is a partner is somebody who you have lived with for a period of 2 years, or somebody who you are married to, so your spouse, or somebody who is your fiance or fiancée. So fiancé, I think, is for the male, and then fiancée is for the female. So in terms of a partner, you have this category of people. So somebody that you're married to, somebody that you've been living with for a period of 2 years, or somebody who is your fiancé or fiancée, because some people will apply to come into the UK as a fiancé or fiancée to be married in the UK. So you have all these category of people who are known as partners. So in general terms, these are the kind of people that will call a partner under our immigration rules. So if you fall under these categories, then you are known to be a partner. And of course, if you are saying that you have lived with this person for a period of less than, let's say, a year, or you've lived with this person for less than 2 years, and you have built family life with that person, so you have a child with this person, then you could argue that this person is also a partner, because you have some sort of family life with this partner, and so even though their rules specifically state that it should be for a period of 2 years. Of course, because of the fact that you now have a child with this person, using case law, you can argue that this person can still be somebody who is defined as your partner. Yes.
Criteria with the person, the partner.
Sorry.
You have to show proof as in marriage.
Definitely. So if you're saying that this person is your partner to whom you're married to, then obviously you have to show evidence that you are the partner of that person. So either that you're saying you are married to this person, so you're going to show by way of your marriage certificate that you are married to this person, or you're going to show that you've been living together with this person for a period of 2 years. So usually you're saying to the caseworker working on your case that this is evidence. Yes, maybe I don't have the right documentation, but my partner has been willing to maybe put my name on a few bills that come through the house, or the GP services know that you are registered to that address, and you can collect GP letter to say that you are registered at that particular address. So yes, you have to show them by way of evidence that you are living on the same premises as your partner. So either that that partner is somebody you lived with, or somebody that you are married to, and therefore that is the only way that the caseworker is going to know that you are truly a partner of that person.
So making this application, requirements are.
So our immigration rules are quite broad. You would see under our Appendix FM that there are so many rules for family life under Appendix FM. And then specifically when you look at our partner routes under Appendix FM, you would see that, of course, you have to meet certain requirements to be able to make the application under this route. And so you will have suitability requirements, for instance, means that you should not be in breach of any of those sections in order to make an application in the first place. And then usually, even if you look at it carefully, there are those that are mandatory, and then there are those that are discretionary. So that means that even if you're in breach, the Home Office can choose to grant you leave or not to grant you leave. And then the mandatory ones are the ones that we usually say pertain to somebody's conduct. And so sometimes when it comes to our suitability rules, they will usually focus on the fact that a person may have a criminal conviction for which they have received a sentence of 12 months or more, and that, for instance, they may not be conducive to the public good. And if they have received any form of deportation order or exclusion order, then those people, I would say, would not be able to apply under this route because they are in breach of certain suitability requirements. And those are the mandatory ones. And then you have the non-mandatory ones, like using false information or documents in previous applications, or not being able to pay fully your immigration litigation debts, or not being able to pay NHS debts that you have, or not being able to give a reasonable excuse why you can't attend an interview. All of those are discretionary factors that they look at when you are applying under this route. So, of course, if you are able to say that maybe I haven't been in breach of some of these rules, I can go ahead and make an application under this route. And then you have other factors such as the relationship. So if you are saying that you are married to this person, they want to know that the relationship that you have with this person is genuine. You haven't got any other relationships ongoing with somebody else, and so you're not in a prohibited degree of any relationship. Of course, that you are not related to this person, that you also can show that you are 18 and above. You also have to show that you've met this person. So there's a whole category of things they look at when they're looking at the relationship factor or the relationship requirement. And so that means that if you're able to show them that at least your relationship is genuine and subsisting, and there isn't any other subsistent relationship, then of course you have to be able to show by way of either a marriage certificate or the fact that you have lived with this person for a period of 2 years. And in that sense, you should be able to relate to them by way of evidence, because as we always say, you can't make an application in this country without showing your evidence, and evidence is necessary to be able to make your case. And so, yes, you should be able to show that you have a relationship with this person. And then when it comes to another one of the factors, so we are looking at the immigration status requirement, and they look at the fact that this person who is making the application is not here as a visitor. They're also looking at the fact that this person who is making the application is not in breach of any immigration conditions or rules. And this is where most people fall foul. And that's why I decided to look at this topic today, because if you are in this country as an overstayer or somebody who came here illegally, then that means that you are in breach of certain immigration rules or certain immigration conditions. And that is why you are not able to make the application as you would like to. And so the rules are such that if you can't meet a certain requirement, then you should be able to meet a certain exception to the rule. So, for instance, you're not able to meet the immigration status requirements because you are an illegal immigrant here in the UK. You've come to form a relationship with a person who is British, and you're thinking, how can I make this application to the best of my ability without having to be refused? And most of the time, most people will go ahead and make the application without having any knowledge whatsoever as to what they would be going in for, because the Home Office have their own guidance, and they have factors to be considered when making such applications as well. And so, yes, there are exceptions to the rule. They are in two parts. So you have EX1A and then you have EX1B. And when you look at our exception 1, it would state that you should be able to show that there is a child to whom you have parental responsibility. And so that child should be under 18, and that child should be living in the UK, and that child at least should show that they have British citizenship or they have settled status here in the UK, which means they have indefinite leave to remain, or that they have lived here continuously for a 7-year period. Of course, they will also have to be able to show that it will be unreasonable for this child to go back to the country where this parent is from. And so if you are saying to the caseworker, maybe my child is 5 years old, my child has indefinite leave, or my child has British citizenship just like their mother does, and I play a role in this child's life. I take them to school, I go and pick them up, I even sometimes take them for their GP appointments, and I do everything that I need to do for this child. Of course, if you are able to show that you have that parental relationship with this child by way of a school letter from the GP, the birth certificate of this child, if you're even a step parent, it could be that the the other parent can even write a supporting letter to say that the things you do for this child as well. Of course, all these things matter. And so once you are making this application, you should put everything forward that would show that at least you are playing a role in this child's life, and therefore it will be unreasonable for this child who is British or who is settled here in the UK to be removed to go to the country from which you came from. So that's EX1, which is exception 1 to the immigration rule requirements. Let's look at the second part of the exception. So the second part is to say that, yes, of course, I don't have a child who is under the age of 18, but I have something that will be significantly difficult. So you must be able to show that there are insurmountable obstacles, which in other words, you are able to show that there are going to be significant difficulties to you and your partner continuing your life outside the UK. So, of course, if we say insurmountable obstacles, what do we necessarily mean by that? And another way is to look at it in the form of different case laws that have sort of looked at what we could say is an insurmountable obstacle. And so I was saying that another way to define it would be some significant difficulty. And so when you look at significant difficulty, what could be something that is so significant which would be seen as harsh or unjustifiably harsh treatment if the Home Office were to refuse your application and say that you were to go back to the country from which you came from? And most people who are in this situation may not even have a child. And so what could be something that they would term as significant difficulty? Is it that they have a medical issue for which the only treatment that is provided is something that can be provided only here in the UK? Is it that they may have some sort of difficulty raising money because the fact that they would return to another country where getting that treatment will be very expensive would mean that they can't go to that country and therefore they have to remain here? Doesn't mean that, for instance, somebody who is from a country where there is a lot of, should I say, rife going on politically and also physically, and therefore in a setting like Sudan where there's, should I say, no government, it will be difficult for that person to return and say that they are making an application from that country. So what would you be able to term as significant difficulty? And you should be able to show evidence of this. If it's a medical issue, you should be able to show evidence that there is this illness, and obviously for this illness, there is no treatment in the country that you'll be going to, or maybe it will be too expensive in that place where you will be going to, in terms of the fact that the monies that you'll be raising will be clearly impossible to raise in a short period of time. Or it could be the fact that because of the political turmoil in the country, there is no way that you'll be able to go back to the country. So there must be evidence from the country. It could be articles, it could be evidence from the government website. Different things can be used to show that, of course, because of what is going on, there is no way that I could return back to this country and be able to make such an application. Yes. Hi.
Yeah. Yes. With all first event, someone he wants to remain anonymous, is asking, what if you are gay and going back to your country, you feel your life will be wrecked, you'll be killed or something like that? Will the Home Office accept that?
Of course. So if you are saying that in your country homosexuality is not accepted and you can have evidence, so it's not just saying it, you should have evidence to back what you are saying. So if you're saying that in your country, homosexuality is not accepted and people may be, should I say, mistreated in a harmful way, or even sometimes killed, you should be able to show by way of articles or evidence that, hey, this is what can happen to me if I were to return to my country of origin, to make such an application. And then, of course, you can put that through as well. So yes, all these things are part of the reasons why, of course, we are looking at this subject, because we want to know what is insurmountable obstacles. What can we use as evidence, or what can we say is something which is significantly difficult or is going to create an obstacle to me returning to my country of origin to make this application. So as we all know, usually they will say if you don't have any status and you are making a partnership application, it is better to make it back in the country you are from. But if there is something that you think is a significant difficulty to you returning, then you can make the application from within the UK. So yes, of course, if he has evidence to show that in his country of origin, homosexuality is not accepted, this is what can happen to him if he were to return to that country, then of course, he should go for it. He should definitely go ahead to make the application. So there is a wide range of reasons or factors that somebody can say would be significantly difficult for them to return to their country of origin to make that application. And we have the case of GM Sri Lanka, where they said that in that case, insurmountable obstacles should not be seen as the only factor that should be considered, but it is also a relevant factor, or one of the factors to be considered when the Home Office is making their assessment as to whether a person should be looked at, in the sense that there is that high proportionality test in terms of whether the public interest is for them to continue to remain in the UK, or their family life, their right to family and private life will be affected if, for instance, the Home Office were to refuse their application. So yes, the Home Office has a wide range of factors to consider, but the insurmountable obstacle should not be the only factor that they consider in terms of making the assessment. And so when you are making your case that, of course, you have this significant difficulty, you have to be able to present evidence to back what you are saying. And then they will look at the other factors, such as the fact that you have formed family life with such and such a person, and you are making the application based on the fact that, based on your relationship with Mr. A, and the fact that it will be very difficult for you to go back to your country of origin. That is why you have chosen to make your application from within the UK. And so, of course, there are different case laws that will look at what insurmountable obstacles are. And of course, if you want to make such an application, you should be able to go and see a legally trained solicitor, or somebody who is trained, so that they are able to look at the right, should I say, circumstances in which you are in, to be able to make the application on your behalf. So yes, if you can't meet certain requirements within the immigration rules, and you are able to meet one of the exceptions, which is either you have a child, or you are able to show that there will be significant difficulties returning to your country of origin, then of course you can make the application from the UK.
Correct me if I'm wrong. I believe there are different routes to this application, and the 10-year. Am I right?
Yes, but in terms of people who don't have immigration status, or do not have leave to remain in the UK, they would usually be put on the 10-year route.
Okay. So you cannot decide which route you want to.
No.
Because if I would have preferred the 5-year route because it's shorter.
That's what most people would love to do.
Yeah, Eunice, I'm just wondering, is there any financial commitments to be met?
So,
with respect to the requirement?
So not necessarily. If you are somebody who doesn't meet the immigration status requirement, and for instance, you are saying that your partner is working and your partner earns a living of so and so, maybe your partner even earns more than the threshold of 18,600. But because you are not able to meet at least one of the requirements, EX1 will apply and you will be put on the 10-year route. So it doesn't matter whether you are able to meet other eligibility requirements such as the relationship the relationship definitely is a mandatory requirement. So such as the financial requirement or the English language requirement, unfortunately, you would not be able to say that because you have met all the other requirements and therefore they should put you, let's say, on the 5-year route to getting your settlement. So when it comes to making this application, they want to be able to see that as much as possible, though you don't meet one of the requirements, one of the exceptions to the rules will apply to you. And so if you can show clearly that you either have a child who is under the age of 18 or that you face significant difficulty if you were to make the application from outside the UK, then of course, this application would mean that you would be making the application under the 10-year route rather than the 5-year route where you meet all of the requirements. So you should be able to meet all the requirements to be able to be put on the 5-year route to settlement. In this case, if you meet the financial requirements, you meet the English language requirement, and you don't meet the immigration status requirement, then you would definitely be put on the 10-year route. If you're able to show that, of course, your living conditions are such that because you don't work, there is no way that your partner can continue to maintain you because currently the living expenses are over and above what you and your partner can obviously pay for, then it means that you're making the case for them to remove the no conditions, for you yourself. So when you make the application, you're telling them our expenses are so high, there is no way that we'll continue to keep going without having recourse to public funds. And therefore, there must be compelling and compassionate reasons why they should not impose that no recourse to public funds on your leave. And so if you can show that there are those compelling factors, or it is likely that you and your partner will be destitute, which means that you will not have a place to live, you will not be able to meet your essential needs, then of course they wouldn't impose that no recourse to public funds on your leave when it is granted.
Ladies and gentlemen, just joined us. This is the Legal Hour show on Heritage TV, hanging out with Vicky. And as usual, we have a representative from BWF Solicitors, and she's in the person of lawyer Eunice Achampong, and she's also one of the partners at BWF Solicitors. Today, we've been discussing applying under the partner route. If you have any questions, please feel free to send your questions to us on our Facebook, YouTube pages at Heritage TV. You can also send your questions to BWF Solicitors on Facebook as well, because they are also streaming live this show. So we'll be able to, pick up your questions to discuss it. between myself and Lawyer Eunice. So send your questions. We'd like to hear from you. Lawyer Eunice. Yes. I've got Kunle, who sent a question. Hi, Kunle. I met my wife at a wedding reception 4 years ago, and we have been married since 2nd October 2018. I have indefinite leave to remain, and she's seeking to rely on me to put in an application. We live alone as my children have grown and have left home. I was recently diagnosed with high blood pressure, and I've had type 2 diabetes for some years now. I have lived here over 30 years and want to find out if my wife puts in an application, whether it will be successful. For Eunice.
So this is one of those questions where you say to yourself, the Home Office should have mercy and obviously make this application successful, because you want the person making this application to be able to be granted leave as much as possible. So you have a typical couple, they're married, the one is looking for the spouse to be granted, leave, or to be granted stay in the UK. And as I said, there are different factors that the Home Office has to consider when making this application under the partner route. So usually, as I was saying before, if you are saying that you are in a relationship with this person, you should be able to show. So they have said that they are married. They were married since October. And of course, if you are saying that you are married, then there should be evidence of your marriage certificate. So your marriage certificate is one of the things that you have to show. You also have to show that your relationship is subsistent. So it means your relationship is ongoing. So if you're saying your relationship is ongoing, do you have any proof of address that you are currently living together? Is there something that you can collect from your GP? Is there something that you can collect from your utility providers? Are there hospital letters, bank statements, or anything of that sort to be able to rely on to say you are living with this person? If so, then of course include those things as evidence that you are in a subsistent relationship or ongoing relationship with this person. So once you're able to show that you are able to meet the relationship requirements, and of course, it goes without saying, you shouldn't be in another relationship elsewhere. So if you were previously married, then of course you should be able to provide evidence that you are divorced or that you are no longer in a relationship with the other party if you were previously married. So once you are able to meet the relationship requirements, you then move on to the other requirements that they would be looking at. And that includes the fact that you should be able to show that you are not in breach of any immigration conditions, or you are not in breach of any immigration rules that are in place. And that is why we are talking about this today, because you don't have that immigration status. And so, of course, you can't meet that requirement. And because you can't meet that requirement, that means that you have to be able to show that you meet one of the exceptions. In his question, of course, he says that his children are not in the house. So his children have left home. And that means that there are no children for this family, because he's lived here over 30 years. He has grown children, but he doesn't say whether his wife will be able to have children, because of course, you don't know what the ages are. But if it's the case that the wife is not able to have children because maybe she's an elderly woman, or for one reason or the other, they have not been blessed with children, then of course you are looking at EX1B, or exception B to the immigration rules, where there are no children, but you should be able to show that there are insurmountable obstacles or some significant difficulty to you applying from the country that you come from. So let's say that this person is from Cote d'Ivoire. They are making this application. They want to be able to show that there is no way that they can go back to Cote d'Ivoire to make an application from there. Now, this partner, who is somebody who has indefinite leave to remain, is saying that previously he was diagnosed with diabetes, type 2 diabetes, and that, of course, he now has high blood pressure. Obviously, if you were to look at searches, whether Cote d'Ivoire is able to provide medication for high blood pressure, I'm sure there will be medication available from Cote d'Ivoire as to whether they can provide medication as to high blood pressure and also type 2 diabetes. Then you now have to look at the cost, whether maybe the cost of such medication will be something that that person will be able to meet. I'm not sure if they will be able to meet the cost, because I'm not sure how much the cost of such medication would be in, for instance, Cote d'Ivoire. So if they look at the cost and they are thinking, if I were to get this on a monthly basis, this is how much it will cost me to go and get such medication. If I were to be in the UK, it wouldn't cost me anything because the NHS will provide it to me for free. Or because I live in the UK and I'm a settled person, some of these things are not part of my private cost. And that is why for me to go back to a country where my partner is from to be able to get these medications is something that will be difficult for me. But is it difficult in the sense that maybe you are saying that something like this will cost maybe £10 a month in Cote d'Ivoire? If that is how much it's going to cost, then they would say, unfortunately, this is not something which is significantly difficult, because £10 a month compared to the UK, maybe I'm sure you can, have the, should I say, resources to be able to pay for something like this on a monthly basis. So it has to be something that is significantly difficult, that you think they will say to you, this will be harsh, for them to tell you to go back to your country where, for instance, there is no treatment, the medication cannot be gotten in that country whatsoever. Is that something beyond your capability? Or is it because you are saying to the Home Office, yes, of course, I'm not capable of paying this, paying for this amount of money. So let's say he's a pensioner, because I'm not sure whether he is a pensioner, and currently he's just receiving his pensions. If you are saying that you are currently receiving pensions of a certain amount, and therefore your wife is not working, you are currently at home buying medication for high blood pressure, and you're treating your type 2 diabetes as well in the country, and therefore you have to get your insulin and other medications for your high blood pressure, which will cost more than £10, then of course you should be able to provide that evidence from that country that it will be significantly high or expensive for you to be able to get medications from whichever country that your partner is from. And then, of course, if you are saying that, you should be able to show it as well. And most of the time, most people will say, oh, yes, it's expensive. And then when you compare the cost, it's not significantly pricey. And so that in itself will not cause the caseworker working on your case to think that it is something which is significantly difficult for the other partner and yourself to go to the country from which she's from to be able to make the application. So when we are looking at applications like this, they want something which is going to be significantly difficult, not just the fact that maybe the medication will cost maybe 10 or 20 pounds in the country that you're from. They could easily say, well, she could go back to the country where she's from to make the application if you are able to meet all of the other requirements. So maybe you are able to meet the financial requirement, you're able to meet the English language requirement, then she should go back to the country where she's from, make the application from there, and then come back to the UK. It's not that simple, because usually if you've been here illegally for some time and you go back, there is that automatic 1-year ban, and then you should be able to abide by that before you can even make an application to return to the UK. So sometimes you should weigh all of this before you make the application, because they will refuse it if they do not think that there is insignificant or there's significant difficulty to you going back to the country where you're from to make that application. So there are certain things that need to come into consideration, not just the fact that you have an illness and it will be expensive there. They have to calculate what the cost is here and what the cost is over there. And if it's significantly lower, then you really haven't made your case. But if you are saying that because of the expense and maybe because of what is going on in your country of origin, maybe where you are coming from, there's a lot of harm being done to people your age, because maybe there's cultural, should I say, hardships in terms of where you're coming from and all of that, then you can make a case in regards to all the other factors that make it difficult for you to make an application from your country. But if it's just to do with the money that you would pay, then unfortunately that might not be seen as being significant enough to prevent them from refusing the application.
So then I guess you have taken the information Eunice has given you, and I believe she's done justice to the questions. Ladies and gentlemen, we've got another question from Marilyn. She says, my partner and I have been together just over a year now, and we have discussed putting in an application for the foreseeable future. Have no health conditions, whether that's he. What can we do in terms of submitting an application for him?
Okay, so in terms of a question like this, obviously you don't have any obvious significant difficulties, because they're saying to you, we are married, and of course we want to see if we're able to make an application from the UK. And of course, we have cases where people will come into the office, they will say, well, we would like to make an application. And this is one of the common questions. And the whole intention behind Parliament making these decisions as to whether somebody who is a partner should be able to make the decision from the UK is such that, because they know that most people would try and make an application from the UK if it was that easy, they know that this is something that they have to curb, and that is part of creating that environment where it will be difficult for such people to make an application, because they're thinking, if we make it available to everybody, then everybody will just get married and just decide to make an application to remain in the UK. And so because they want to curb immigration numbers on a whole, the requirement is that if you don't have any insurmountable obstacles, or you don't have a child who is under the age of 18, then you should be able to go back to the country in which you are from to make the application. It is different if you have a child who is under the age of 18, or children who are under the age of 18 who have lived here continuously for 7 years. So it's either that they've lived here continuously for 7 years, or that they are British or settled. So sometimes, even if you have children and they are not 7 and above, there is that difficulty in making these applications as well. So you should be able to show that maybe the child who is under 7 is either British or settled. And in most cases, even the children that they have may not even be a child from this relationship that they are, should I say, in at the moment. So maybe they've met this settled person, or they've met this person who is British, but maybe the child that they have may not even be from this current relationship. So the child himself or herself hasn't got any status in the UK. And you want to be able to make this application. And most of the time, where there is a child outside of the relationship, if that child will be turning 7 soon, you advise that person, wait till the child turns 7 and then just make an application for leave to remain for yourself and the child. In that way, you are creating some hope for that person as well, because at least when the child turns 7, they know that they will be able to make the application from within the UK. And we have so many different case laws, and the fact that the Home Office themselves have in their policy that once you are able to show that the child has also formed family life and private life in the UK, they can make their application to remain in the UK, and you can also rely on them to be able to get your further leave to remain in the UK. So that's fantastic if there is a child like that in the relationship. But if in this case there is no child whatsoever, and you're looking at the fact that maybe we are looking at the two of us, we're alone, maybe for some reason or the other, they may not have had children, or maybe they might be thinking about having children in the future. If that is the case, then of course, once they have the child will be automatically British because the father is settled or the father is British in that instance. And so maybe they should look forward to having a child. And then if they do have a child, then that child will be automatically British. If it is a case that there is no child whatsoever, they cannot have children for any whichever reason, then it will fall to the fact that there has to be something which will be significantly difficult for them to return to their country of origin to make the application from there. And that is why at the beginning I was mentioning the fact that there has to be some sort of medical reasons, which, for instance, you think that there will be no treatment whatsoever in the country of origin from which you are coming from, or it will be significantly expensive there, or there must be some turmoil in the country, whether it's politically or physically, there must be something that should make it significantly difficult for you to return to that country where you are from to be able to make the application from there. So, of course, they will consider the family life that you have created here in the UK, but they also have to look at the fact that it will be significantly difficult for you to return to that country to make the application from there because of what maybe you are suffering, or what maybe your partner is likely to suffer if they return to your country of origin. So all these factors are factors that the Home Office will also have to consider when they are making their assessment. So like I was saying at the beginning, is the public interest so great that when considering your individual rights to family and private life, the public interest is weightier. So it means that maybe because you don't have leave here whatsoever, and the immigration rules are such that you are saying to them you don't have any children at the moment, you are not likely to have any children, there are no issues in terms of going back to your country, then it means that they are likely to refuse it unless you are able to show that you have that significant difficulty to return into your country of origin to make that application. So it has to be significant. It's not just something which is difficult, but it has to be significantly difficult for you to return to that country of origin to make the application from there.
What you're saying, it looks like having a child, the children, your makes it easier.
Yes.
The application is successful, right? Okay.
Definitely.
Okay. Yes, the absence of any further questions, any last words, maybe summarize what we've discussed so far?
Yes, I think most people were thinking, what else can I do if I'm not able to make the application because maybe, for instance, I don't have any insurmountable obstacles. And so if you look to our immigration rules, if you are looking to make an application based on the fact that you have formed private life in the UK, so not just family life, if you've also formed private life in the UK, under our immigration rules, you look at paragraph 276, you see that there is the rule where you can show that if you've lived here for a continuous period of 20 years, that in itself is saying that you have formed private life in the UK. And as long as you are able to show that you have evidence for each year that you have lived here in the UK for that continuous period of 20 years, then of course you should be able to make an application based on your private life. For children, of course, like I was saying, if they are able to show that they've lived here continuously for a 7-year period and they are under the age of 18, they should be able to also make that application. And then you have people who came here when they were younger and maybe for one reason or the other, they've never been able to make an application. So they are under the age of 25, but above the age of 18. If they're able to show that they've lived half of their life here, so let's say, for instance, they came here when they were 10 years old, now they are 22 years old. As long as they are able to show that they've lived here for 11 years or more, they can make an application based on their private life to say that, yes, they formed private life here in the UK, and therefore they want to make an application for further leave to remain. So there are those options for people who may not necessarily have the opportunity to be able to make the application under the partner route, but they have formed private life and therefore they want to be able to make such an application to be able to regularize their stay here in the UK. And of course, now that people who are EU nationals now can have pre-settled status, which is limited leave to remain, or settled status, which is indefinite leave to remain, they too have the opportunity from the 1st of January, which is the 1st of January 2021, to be able to make spousal applications under the immigration rules. So if you're an EU national and you have limited leave to remain in the UK, you can make an application for somebody who is also your spouse or your partner as well. So of course, that is open, but like I said, you should be able to show insurmountable obstacles if there are no children who are under the age of 18 in the relationship. So yes, I just wanted to mention there are other options. Maybe it might not be an option for some people, but it will be an option for others as well. So I just wanted to mention that as well.
For our viewers.
I know that most people will think twice, especially before they make these applications. And I would say, as much as possible, seek legal advice. And as Vicky said at the beginning, I am one of the solicitors at BWF Solicitors. We are situated in London. So we are on the 4th floor of Anna House, 214 to 218 Tottenham High Road, London, and the postcode is N154NP. So N154NP. And our office telephone number is 0208 493 7340. So 0208 493 7340. And my number as of office hours is 075 3581 3910. Thank you.
I've realized that people have been calling your out of office hours, even during your, during the day.
Yes.
Which I really don't get it. So may I please advise our viewers, please, if you call a lawyer, Eunice, or any of the team at BWF Solicitors, and you want to call between 9 to 5 p.m., I would advise you call the landline number for you to get a quick response. Because Eunice is just one person. She cannot, handle 2 to 3 lines at the same time. So if you're able to call the office desk directly, your message will be passed on. That is if you want to speak directly to Lawyer Eunice during working hours, you can call the office reception line, and definitely your message and details will be passed on to her, and she'll be able to get in touch with you. Yes, and I believe that today between 4 and 6 o'clock, BWF have their a program on Facebook Live known as the Community and the Law. They have this legal education program every Saturday from 4 p.m. to 6 p.m. I always tune into this educative program as well. So I will encourage each one of you, tell your friends, families to join in to the Community and the Law program, by BWF Solicitors on Facebook, 4 to 6 p.m. And today's topic is the type of visa needed to get married in the UK. The type of visa needed to get married in the UK. So please join us again on BWF platform live at 4 p.m. On that note, I'll say a big thank you, especially to Lawyer Eunice Achampong, and also to the team at BWF Solicitors, to Uncle Ben for allowing Lawyer Eunice to come on our platform each and every Saturday to educate us. Thank you so much, and I hope to see you at 4 p.m. on the BWF Solicitors Facebook platform for another interesting legal education. On that note, thank you so much, and I hope to see you next week, same time. I also want to thank our sponsors as well, BWF Solicitors, Victim Estates, and Eagle Heights International School. Thank you. Without you guys, we wouldn't be able to come here every Saturday to educate you. So thank you, take good care of yourself, and have a lovely day. See you next week. Bye-bye.
The demands of our clients, we always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback, reviews from our clients. We are located at 7 Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society Accreditation helps demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. We are solicitors. We're here to help you with your legal services.